Okay, that was chat. Chat's kind of fun, but if you have a question, please just stick it in the Q&A. We'll get to it. That's all. I'm going to disappear. Good.
Okay. Dr. Kubic has been executive director of the ACLU of Florida since January of 2019. And before that, he had the same role as executive director of the ACLU in Kansas for 3 years. He has more than 15 years of experience in civil liberties, civil rights, and racial justice work. He has a BA from George Washington University, as well as a master's degree and a doctorate in Black politics from Howard University. His first book, Freedom, Inc., and the Fight for African American Empowerment, was published by the University of Missouri Press in 2016. Mike is going to talk about recent developments in the Amendment 4 lawsuit, the outcome of which could well determine whether Donald Trump is sent packing in November. Amendment 4 was passed, as I'm sure you all know, by 65% of voters in November 2018. And at that time, it appeared likely to restore the franchise to some 1.4 million former felons. It was projected that the majority of them would register as Democrats. And there was a sense of celebration, if not giddiness, in the air. At the time, my aunt, Marion Kulick, was less sanguine. She said, just wait until the Republicans get a hold of it. And as always, she was right. So I'll leave it there and let Micah take it up.
I do want to throw in one quick thing, though. If you want to see him and not us, on the upper right-hand corner of your screen, if you haven't been using Zoom, move the mouse there and you'll have a choice to go between kind of grid view and speaker view. Click on speaker view and you'll see the person who's talking, which won't be us.
Oh, good. Yeah, there we go. Okay.
All right. Well, good evening, everyone. Thank you, Michael, for having me here this evening. I'm happy to be able to spend a little bit of time with you this evening. I'm sorry that we're not able to be together in person, obviously, but glad that we're able to spend some time together digitally instead. So my name is Micha Kubic. I'm the executive director of the ACLU here in Florida. For those of you who don't know, the ACLU is a national, nonpartisan, non-political organization founded over 100 years ago now for one reason and one reason only, and that is to defend the rights and freedoms that belong to every single person in this country under the Constitution. And I think it's especially important that we say nowadays every person is covered by the Constitution, because there are some folks running around in Washington, in Tallahassee, who seem to think that only some people are covered by the Constitution, who think that rights and freedoms belong only to some privileged few and not to all of us, not to everyone, not to every person in the country. And that is, as Joe Biden would say, malarkey, but that is, in fact, what some folks today think. And it's our job at the ACLU to push back against that. I have to also give this little disclaimer at the beginning that I am obligated to give, which is that I'm here tonight for educational and informational purposes. My participation is not an endorsement of the Democratic Party, its candidates, its agenda, et cetera, et cetera. I will speak to any group that invites me because we are a nonpartisan organization, and so I'm obligated to say that right at the start. So I wanted to talk a little bit tonight about what we're working on in the world nowadays. I think it is fair to say that right now it seems like the entire world is on fire. It seems like fires are raging all around us. It seems like the fire is out of control, frankly. But one reason that I am very, very proud to work at the ACLU, one reason that I am proud to stand arm in arm with our tens of thousands of supporters in this state, is that when the fire is raging, we say, into the fire we go. We don't cower away from it. We don't wait for the ashes to be there and then sort of wind our way through them. Instead, when we see a fire, we say, into the fire we go. We take it on, we challenge it, and we work to make sure that when the fire is out, something new and better is built in its place. And I think that is definitely the world that we confront now, where there are lots of fires raging, many of them that are specific to COVID and to this pandemic. But to be clear, many, many, many fires that were raging before that as well. And it's our job to be working on both of those fronts simultaneously. And I think there's no doubt that the biggest fire we have been confronting in this state prior to COVID has been around Amendment 4 and the battle for voting rights. And that is so important because it impacts so many other things. There's no other way to defend all of the other values that we share as Americans without access to the ballot, without the defense of voting rights. We should also be very clear that there has been a long fight about voting rights. In fact, the fight over voting rights is as old as the country itself. From the very beginning of the country, there have been folks who have been arguing that only a few people, only some tiny subset should have access to the ballot, and the rest should be without it. And that's because access to the right to vote is really not about going into the ballot box and pulling the lever or filling in the little circle or punching the button on the screen. Voting rights are really about a marker of your citizenship. It's a marker of who counts and who doesn't, who's included in the community, who is excluded from it, who we say we value, and who we say has no value at all. And that's why battles about voting rights have been so pitched and are so much more serious than just a battle over getting to vote for one politician or the other on election day. So if you go back to the beginning of the country, from the very beginning, from the day the Constitution was signed, there were folks who were arguing over who should have the right to vote. When the country was founded, back on the 17th of September, 1787, when the Constitution was ratified, just 6% of the people in this country were allowed to vote. Rich white men. That's it. Rich white men. Not just men, not just white men, rich white men were the only folks who had access to the ballot. And over the years, we gradually expanded access to voting rights. We fought long and hard about it. We fought a war about access to voting rights. The women's suffrage movement fought for voting rights. And of course, the civil rights movement in the South. Folks literally gave sweat, blood, and tears in order to pass the Voting Rights Act of 1965 and to make sure that people had access to the ballot. Over time, we gradually came to the consensus that we do in fact believe that the majority of people in this country should have access to the right to vote. We would encourage people to vote, and we would do what we could to make it easy for people to vote. But over the last 20 years, that consensus has gradually unraveled. It culminated a couple years ago when the Supreme Court struck down a key part of the Voting Rights Act of 1965, but there have been many, many, many other attacks on voting rights since. Even though those attacks have been happening, you only have to look at Wisconsin a few weeks ago, where the outrageous legislature forced people to come and vote in person during the midst of the pandemic. You only have to look just a few weeks ago in Wisconsin to see that voting rights are still under attack. But at the same time, we have been pushing back, and there have been victories for voting rights. The single biggest victory in this entire country was right here in the state of Florida, when in November of 2018, as Michael mentioned, voters in this state voted for Amendment 4 by a margin of 65%. 65%, not 51%, not 49%, 65%. More people voted for Amendment 4 than have ever voted for Ron DeSantis or any member of the legislature. an overwhelming majority of Floridians said that they wanted to restore voting rights to returning citizens, wanted to give back 1.4 million people the ability to go and vote, and more importantly, to have their citizenship and their human dignity restored. Now, keep in mind that Amendment 4 was only necessary in the first place because the legislature had refused year in and year out for decades to undo this horrible, unjust, deeply racist policy. Because the state constitution before said that folks who were convicted of a felony offense were forever barred from registering to vote. And why did the Constitution say that? Because back after the Civil War, in the years immediately after the Civil War, the Florida legislature said, we're going to pass this amendment. And they specifically said they were doing it to stop Black men from voting. You don't have to speculate about that. We don't have to guess what their motives are. You don't have to read anybody's heart. You don't have to look inside their mind. They said it out loud repeatedly in the public record. You can go back and read the minutes of the meetings of the House and Senate of Florida at the time, and they say out loud that the only reason they're doing this is to stop Black men from voting. And yet, even though they said that out loud and everyone knew it, it took us 150 years. It took us 150 years, repeated journeys up to the swamp that is Tallahassee, to ask the legislators over and over again to do something about it, to be refused, to say we don't care about this. And then folks in communities had to get it on the ballot in the first place. They worked hard to get it on the ballot. We at the ACLU worked hard to get it on the ballot, and then to get 65% of Floridians to say this is the right thing to do. But as has already been mentioned, immediately after it was passed, in the weeks in between its passage in November and when Ron DeSantis took office as governor in January of 2019, he wasn't really saying much in general. You couldn't really find him anywhere. He wasn't really commenting on hardly anything that he was going to do. And yet he popped his head up out of a gopher hole to say that he thought that implementing language was needed. They had to pass another bill in order to implement Amendment 4. And that was total garbage. It was nonsense. You don't have to pass bills to support the Constitution. The Constitution comes above the law. There was no implementing language needed at all. All they had to do was to do it. And yet the governor and the legislature said they thought they needed implementing language. And the reason for that very quickly became clear because it became clear that when they said implement Amendment 4, they really meant repeal Amendment 4. And so anytime you hear them talk about implementing Amendment 4, you should just strike it through in your mind. Get a big black Sharpie marker, strike it through in your mind, and replace that implement word with repeal or undermine instead. And that is exactly what they set out to do. They passed a bill that essentially creates a modern day poll tax. It says that in order to register to vote, if you are a returning citizen, you first have to pay money. You have to pay these legal fees, fines, obligations. You have to pay money in order to register to vote. And I don't care who you are, where you come from. As far as I can tell, when you look in the dictionary, it says if you have to pay money to vote, that is the definition of a poll tax. We made poll taxes illegal and unconstitutional in this country 50 years ago. They are still illegal and unconstitutional today. And beyond that, they are just plain wrong. Those are not our values. That's not what we should be about. That's not what we are about. And so when the legislature passed this bill and the governor signed it, we at the ACLU immediately sprung into action. I think the governor signed it on a balmy Florida Friday afternoon in July at about 4 o'clock. And by 5 o'clock that evening, we had filed suit in federal court. Representing some individual plaintiffs, along with our partners at the League of Women Voters, the NAACP, Campaign Legal Center, and others. Now, here's one of the things that's especially galling about it. There's lots of things you can find to be galled about on this, starting with the legislature deciding it knows better. In general, I would say there's almost no subject on which the legislature knows better than a random person pulled off the street in Florida, but they thought they knew better. here's what's most galling. When they were asked, and really in particular one fella, a man named Jamie Grant from over in Tampa. I want everyone to remember his name because he, other than Ron DeSantis, he is the leading villain in this particular play. Jamie Grant from Tampa was the chief sponsor of this bill. And when he was asked on the floor of the Florida House how many people would be impacted by his bill, he said, "Don't know, don't care, we can figure it out later after it passes." I think that's just a total dereliction of duty. That is not the way we should be making law in this state or in this country. And it just shows a total disdain for people and human dignity. Since Jamie Grant was not interested in figuring out how many people were affected by this, we at the ACLU decided to do it instead, to do it for him. And what we found out was that of the 1.4 million people who should have had their voting rights restored, the 1.4 million people who Floridians said they wanted to have their rights restored, fully 81% of them would be blocked from registering under this poll tax bill. 81% of the people who should be eligible were going to be stopped because they had not and could not pay the poll tax. And lest you have any illusions about this, we're not talking about trivial numbers either here, right? Like I think sometimes folks have this sense that, oh, it's just $50 here, $50 there. We can like crowdsource the funding and we'll get there and it won't be a big problem. Well, again, Jamie Grant didn't know the answer to how much people owed, so we figured it out for them. And the answer is that in order to fully pay the poll tax of the millions of people, the 1.4 million people who should be eligible, it would take $22 billion. 22 billion with a B. B as in boy, not million, not M as in Micah, 22 billion as in boy. That is just an outrageous, astounding figure. And it's also a figure that you're not going to get the money from that by just crowdsourcing. You're not going to get that from folks doing it out of the goodness of their heart. And the state of government of Florida is certainly not going to come up with $22 billion to pay those poll taxes. Instead, the only way to fix this is to strike down this entire stinking, rotting carcass of a bill that the legislature passed. And that's why we've been doing that in federal court. We got a great judge up in Tallahassee, Judge Hinkle. He gave us a temporary injunction back in the fall. So back in October, he ruled, he found the arguments that the state made to be laughable at that time. But he was also quite cautious in what he did. He wanted to limit his ruling because he knew that Ron DeSantis was going to take it up on appeal. And of course, he did, right? But he was limited at that time while making it clear that he accepted the fundamental argument that people who are not able to pay cannot be denied a fundamental right to vote on that basis. And so he enjoined the state from implementing this law, told them they needed to create a system, they needed to figure a whole lot of stuff out. And he gave them a bunch of time to do that because that was October. He knew that the legislature was going to come back in January and would be there through the middle of March. During that time, first, Governor DeSantis said that he agreed with the judge, that the judge had validated his opinion. When I heard that, I thought maybe my reading comprehension skills had deteriorated because when I read the ruling, it said very clearly that we were right and the state was wrong. And yet somehow Ron DeSantis was of the opinion that his position had been validated. I think he forgot that he was the governor for a little bit. I think a lot of us would like to forget he's the governor, but he forgot, I think, for a minute that he was and didn't realize that he had been ruled against. And then he continued to say that the ruling validated his position even while he was filing an appeal to the circuit court in Atlanta. And in the time I've been doing this, I have to say it's the very first time I've seen someone appeal a decision that they claim supports their position. The answer, of course, is not that it supported his position, but that he was not being candid or honest about what his position was or what the ruling did. So it went to the circuit court in Atlanta. The circuit court, the Court of Appeals there, is a relatively conservative one. It has a reputation around the country for not being the most progressive court that you can get to. And so I think the governor and the legislature were feeling pretty cocky when they went into that courtroom. But they came out with their tail between their legs because the circuit court denied their request to repeal, to overturn the injunction. And in fact, when it went to the full panel, so first there was a small panel, 3 judges who ruled against them, said no, and in fact did so in stronger language than our local judge did. So then the governor asked the entire circuit court, all 14 judges, to rule on this. And he could not get a single one of them, not one, not a single one of them, ruled in his favor. I almost felt bad for him for a moment, because usually you can at least find one wackadoodle to be on your side, and he couldn't even do that. So went to the circuit court, came back, which allowed us to have a trial. We were going to have a trial anyways, but allowed the injunction to stay in place while there was a trial. And the trial was just a few weeks ago. It started 2 weeks ago. And that trial actually happened by Zoom, by one of these web conferences. For the very first time they have done that in the Northern District of Florida, the first time they've done a trial by Zoom. So it was very interesting, but it went well. And the good news is that the judge made it very, very, very clear that he was unmoved by the state's position, that he agreed with the position that we had put forth and that he had supported in the fall, that you cannot stop people voting on basis of inability to pay, that he thought this was racially discriminatory, that there were enormous problems with it. Beyond that, he was also highly, highly, highly irritated by the state, because he had made it clear to them long ago, back in the fall, that he expected them to be doing something to implement his ruling and to come up with a system for doing so. And yet, when he asked them time after time after time, what have you done to implement my ruling? The answer was not a ding dang thing. Given the opportunity to vote on something, anything about this during this year's legislative session, the legislature simply chose not to. Not just that they didn't not pass something, they didn't even talk about it. They didn't even have a bill that they gave a real hearing to about this. And that irritated the judge greatly, to the point that he said, very well, if you don't have a system for doing this, be prepared for me to create one. So by all accounts, I think the trial went exceptionally well for those of us who were standing up for voting rights. We expect the judge to rule very, very quickly. He said before that he expected to rule quickly. We think that a ruling would come even as soon as next week, maybe in the next couple of weeks, but as soon as next week. And that means that it is entirely possible that this whole thing will get struck down and all 1.4 million people will be eligible to register to vote. We don't know exactly what his ruling is going to say. Obviously, there are ways that he could limit it or slice and dice it in various ways that would have an impact on who exactly is eligible or what steps they need to go through to be eligible. But it is very clear that more people are going to be eligible to register than are today. And we're going to get closer to what the voters' original intent was when they passed Amendment 4 in 2018. Once that happens, once it is clear that more folks can register, our charge, all of our charge at the ACLU, at voter registration organizations, at the political parties, everyone, our charge as a society, as a community, is to do our darndest to make sure that folks do, in fact, register. Although there are about 20% of folks who are still eligible even today, even before the court rules, right? 20% of folks have already paid the poll tax, essentially. We know that relatively small numbers of them have actually registered to vote, in part because there has been so much willful confusion about this that a lot of folks just don't really know what the status is or whether they're eligible or not. We know that tens of thousands of folks who were enfranchised by Amendment 4 have registered, but there are still several 100,000 folks who are eligible today who have not yet actually done so. And then, of course, when the court rules, that pool is going to be an even larger number. And so our charge as a community is to do everything we can to make sure as many people as possible register and participate, because we believe that democracy is strongest when more people participate. Ron DeSantis and the legislature clearly believe that they are strongest when fewer people participate. I believe that we as a community and a democracy are strongest when more people participate. And so that is why we're going to fight this till the very bitter end. It's going to take a while yet, even after the judge rules, and even when it goes into effect. Of course, the governor is going to appeal. He will appeal to the circuit court. He will appeal to the Supreme Court. He will appeal to the intergalactic court. He will appeal to the multi-universal court. He'll just keep on going as long as he possibly can to try and shut this down. But we're going to fight till the bitter end. It took us 150 years to pass Amendment 4. If it takes us 150 years to defend it, that's what we're going to do. It won't take that long, but if it did, that's what we would do because it's the right thing to do. Those are our values. That's who we are and should be as Americans. And so this fire is going to keep raging for a little while yet. We're not scared of it. We're not cowed by it. Instead, no matter how high the flames are, we're just going to keep saying, into the fire we go. So with that, I think I'll stop talking, at least for the moment, and see if there are any questions that folks have that I can answer.
I don't actually see any come in yet. However, I do have one.
I have one.
But apparently, as a panelist, I'm not allowed to put one in yet. So how many other countries allow people to vote from jail? I mean, how many? I never quite understood why people lose their right to vote, but not their right to own property, not any other rights. So what do other countries do about this?
Yeah, so I think first of all, we should be clear that it's not even universal across the United States, right? For one thing, if you are in jail as opposed to prison, so if you're in a county jail, there's a pretty good chance that if you are in county jail on election day, you are eligible to vote there from your county jail. For one thing, the majority of people who are spending time in county jails haven't been convicted of anything. On any given day of the year, the majority of people who are spending time in county jails are there because they are not able to post bail. They haven't been convicted. They just don't have the couple $100s it would take to post bond and to get out. And so since they haven't been convicted of anything, their voting rights have not been taken away. That's why we at the ACLU and our partners are working so hard to persuade local supervisors of elections and county sheriffs to make sure that folks who are in jail who are eligible are able to vote on election day. There are a couple counties across the state that do a good job of that now. There are many others that don't. So that's one piece of it. The second piece of it is that even if you are in prison, right? So prison, convicted of a felony, that's when you're most likely to have your voting rights taken away. Even that removal is not universal across the United States. There are two states, Vermont being one of them, where they don't remove your voting rights at all. You can vote from prison. They do voter registration drives in prison. And the turnout rates in Vermont prison is very, very high because, well, people don't have a lot else to do other than study the ballot and the candidates and figure out who they're voting for. So, you know, even the system within the United States is not consistent. But beyond that, this is a very unusual, very rare practice at all. Most places in the world where voting rights are a thing to begin with, right? Many democracies never take people's voting rights away at all. In fact, because they believe that voting, the right to vote is a marker of citizenship and about human dignity, not a privilege that gets stripped away at will. They never remove those voting rights at all. The United States is really quite anomalous in doing this, and it really is appalling that we do it at all. We're allowed to do it, even though you would think we wouldn't be able to under the Constitution, right? The Constitution mentions the right to vote as a fundamental right on multiple occasions, but the Supreme Court ruled several decades ago that it was, in fact, permissible to at least temporarily take away people's voting rights on the basis of a conviction. And that's why there's been a state-by-state battle ever since to stop doing this. Florida was one of the last states standing in doing this. There are still 2 more that do it, but the numbers there are relatively small, at least compared to Florida. So,
Micah,
other questions? Yes.
just an observation. I thought, and I went and dug it up on my computer, the great case that the Supreme Court decided that constitutionalized libel law back in the 60s had a phrase at the beginning that always struck me, and what you just said kind of echoed it, about we believe the more people that can vote, the better. And Justice Brennan quotes Judge Learned Hand, who was one of the great judges of the 20th century. And in a case, he said of the First Amendment that it presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. And he goes on to say, to many this is and always will be folly, but we have staked upon it our all. And that, you know, that's what it should be. You know, they have distorted it.
That's right. That's right. We should be trying to amplify voices rather than limit them, right? Let's see. I think I see a question over here in the chat, right? That says, I thought the case affects about 17 plaintiffs. Maybe my misunderstanding. Will the decision impact all returning citizens? So it is true that when the case began, we at the ACLU, along with some other organizations, collectively represented these 17 individual named plaintiffs. And the original injunction from the fall that the judge handed down, the temporary injunction, was about those 17 plaintiffs. Those were the people who were in the case. Those were the people he could give the injunction about. However, and so it is true that it affected those 17 people. But what is also true is that at the same time that it was affecting those 17 people, the judge's injunction said, have to create a standard. You have to create a mechanism. You have to create a way for everyone who would be impacted by this that you would use, right? Yes, for the moment, these 17 people are the 17 who I am specifically making sure are protected under the injunction, but you should be creating a standard and a way of protecting everyone that folks who came after would have applied to them, right? It's about a question of the Constitution and the law, right? If there's a constitutional principle that you cannot deny people the right to vote based on their inability to pay, then even if we know that that affects those 17 people who we've already identified, the same constitutional principle is going to apply to everyone. And that is what the judge said when he gave that injunction. Now, the second step of this is that at the same time that that was going on, those of us on the plaintiff's side were preparing a motion to have a class certified. You know, you've heard of class action lawsuits where you affect everyone who is got a particular characteristic. And in this case, the certification of the class of a larger number of people didn't happen in October, but did happen last month in April. And that meant that now there were specific people named, hundreds of thousands of people, who were specifically covered by the ruling in a way they weren't before. The judge and those of us on the plaintiff side, again, like, we're happy to have the class certification. It helps. It makes it easier and quicker to move things. But we want to be very clear that when the court hands down a ruling on constitutional principle, that applies to everyone, even if those people aren't specifically named, right? Reproductive freedom cases, for example, right, oftentimes have an individual woman who's seeking protection of her right to make reproductive health care decisions. A lot of times, by the time that gets to court, the decision has come and gone, right? She's already had to make the choice about what's going to happen in terms of her reproductive health care. And yet it doesn't mean that the constitutional principle that the court puts forward doesn't apply to everyone. It does. And so I think while it is true that the original injunction affected those 17 people and was narrow in that sense, it is also true that the state and some folks in the press made it seem as though that meant those were the only 17 souls who would ever be impacted by it. And that is clearly not true. It's especially not true now that the class certification has been granted. And so whatever the judge does in the next couple of weeks, it is going to apply to hundreds and hundreds of thousands of people, not just those 17.
Got some more good ones.
While you're waiting for another question, Micah, you were good enough to give me the link to listen to the arguments in the trial. And I don't know if I got back to you on it, but it was incredible. I mean, the evidence that the plaintiffs put up on, and I don't know if you could talk about any of that, on the fact that no one really knew how much people owed. If they wanted to pay, they couldn't figure out how much to pay. And then the large number of people who were indigent just by virtue of the fact that they were represented by public defenders, because they wouldn't have been if they weren't indigent.
Yeah, right. I mean, I think the overall approach of the state and others has just been one of shoddiness, right? I mean, it is clear that there is no real concern about people's voting rights by the way that the systems have been designed in a way to make it as hard as possible. We had all sorts of testimony from folks who would call county clerk's offices. County clerk is the one who's supposed to have the information about what you owe, how much it is, et cetera. They would call and they would get 3 different answers for the exact same person, right? One time they would be told, oh, you don't owe anything. The next time they'd be told, oh, you owe 1,000. The next time they'd be told, oh, you owe 50,000. So it was just in shambles. No, there is no centralized system in the entire state for folks to figure out what they owe. We had to create one, and we had to do that by going county by county, doing public records requests in all 67 counties. We had to hire the nation's leading expert on this sort of data to put together a database for us. It cost us nearly $200,000 to create this system, expressly because the state just wouldn't. And you can't expect people to have any sense of what they owe or how to navigate through a system if you don't even create a system for them in the first place. You don't even give them the ability to access the data. So we presented evidence about that. We presented evidence about the huge numbers of people who would be impacted, the way that African American and Latino folks were especially impacted, the way that women were especially impacted. And the judge clearly found it all very compelling, very convincing, based on the comments that he made from the cyber bench. Let's see, I see a question here that says somewhat off subject, but I'm curious. Republicans prevented the House from getting docs and testimony of admin officials and others to testify with no justification. The case coming up to address that series of incidents. I believe the answer to that is yes. It rests ultimately with the House of Representatives to to do that. They so far have shown a willingness to litigate against the administration, including this tax return case that you mentioned. So I would be surprised if there is not a case that emerges from that. It probably will not be especially timely because these things are taking forever, but I expect there to be one. And then I see another question here that says, assuming that the judge does rule in upholding Amendment 4 and implementation, and the governor appeals, you seem to imply we cannot implement while the case is on appeal. So I don't think that's true. It will depend what the judge says, right? Like, it depends on what the injunction is. We know he's going to give a permanent injunction of some kind. We don't know what it will say. We know the governor will appeal. It is possible that, no, it is guaranteed that the governor will ask that the injunction be stayed, right? That it not go into effect while he appeals. We know the governor will ask that. Like, that's normal, right? Anyone who gets an injunction always asks that it be stayed on appeal. It is very, very, very unusual for the request for a stay to be granted. The governor asked for the last injunction to be stayed, and the judge denied it, and the circuit court denied it as well. So I think it's unlikely that that request would be granted this time around. Can't rule it out entirely because anything is possible, but unlikely, which means that it is very likely that the judgment is implemented in the meantime. You know, unless the court intervenes for someone in some way, either appeals court or Supreme Court. If they intervene, that, you know, all bets are off at that point. I think that's relatively unlikely, especially given the short time frame involved here. Because as hostile as the governor is and others are to voting rights, there is the reality that they also have some interest in knowing what the rules of the game are going in, right? Even folks who are on the other side of the issue want to know what the rules of the game are so that they can try and maximize their own chances of success in politics and elections under the rules of that game. Having the framework delayed or struck down at the last minute really complicates everyone's ability to know what to do. And so I think that means it's likely that the decision can be and is implemented in the meantime. That's separate from making sure that folks actually get registered, though, right? I mean, that's, even if there's a legal framework for doing it, you still have to go out and do the leg work of encouraging, persuading, helping folks to actually register. No one can make them register. They have to do that of their own choice, of their own volition. And that, I think, is going to be the challenge. Not even so much because they don't want to, but just because it is, voter registration drives are hard. They're labor intensive, and they're going to be especially hard in this era of social distancing, of people not being able to hang out in front of the grocery store with a voter registration table, of not being able to go to the county fair and do voter registration drives, of not really being able to do door-to-door voter registration. All of those things absence is going to make it harder to implement, even if it is legal to implement.
Nancy
Micah?
raised her hand. Nancy, why don't we allow Nancy to talk? Hang on a second. Let's see if we can do that.
Hi,
Nancy, you want
Nancy.
to ask your question? We'll try to unmute you. You have to unmute yourself.
How's that? Unmute
There you
now.
go.
Oh,
We
there I am.
gotcha.
There you go.
Okay. Yeah, just to
Yeah.
follow up, Micah, do you have any suggestions how we can get people registered in this day and age?
I mean, I think the best answer is that when we know that folks are eligible, right, and we should wait a little bit until we know that folks are eligible, right? We should wait until we know the court ruling, because we don't want to encourage people to register if they are not yet eligible, right? If folks have not paid the poll tax yet, and they won't have to in a few weeks, right? We should wait until we know. And then I think the only way to do it is really to touch reach out, touch people through the telephone or whatever, right? Like I think direct contact is the best way of getting people to do it. And I think right now the only way we have of doing that sort of direct contact is by phone, right? Calling people, asking them about their voter registration status and encouraging them to register, walking them through the online system if you can, right? If someone is able to access the internet and the online system for voter registration, or of course, if folks are getting driver's licenses, things like that, they have the option of registering to vote at that time as well. Walk people through downloading the form, signing it, et cetera, et cetera. But I think the most effective but most labor intensive way is direct person-to-person contact. It's a lot harder to say no to someone when you're talking to them, even if it's over the phone, than it is any other way.
Thank you.
Micah, do you think that in a way,
I think we lost Michael. Michael?
I think we did lose him.
Michael seems to have frozen. Arlene had a question. Arlene, if we get you on speaking, would you like to speak to us, please? Seems to be on a somewhat different subject. Arlene, you around? Talk to us. Arlene. She wanted to know about BAWN, B-A-W-N. That showed up on the.
I believe that is the Banning Assault Weapons Ballot Initiative. I think it's Ban Assault Weapons Now, if I remember correctly. I'm not actually sure what the current status of it is. I know they were trying to gather signatures to put something on the ballot, but I'm afraid I've not followed it super closely to know whether they were successful in gathering the signatures or whether they've gone to the Florida Supreme Court yet or not. What I can say is on ballot initiatives in general, not just this one, is that the state legislature is doing everything imaginable to try and make it hard for people to put initiatives on the ballot, to do citizens initiatives. The last two legislatures in a row, they have passed bills that make it harder and more expensive to put ballot initiatives up for a vote of the people. And of course, this November, there is in fact a ballot initiative that folks will be voting on that says, in order to pass a ballot initiative, in order to actually amend the Constitution, you'll have to pass it not once, but twice, 2 consecutive years, or 2 consecutive cycles. And I think all of those measures are really deeply dangerous, not just because they make things more difficult. That's absolutely true, they do, but because the folks who are behind these things have said out loud very clearly the reason that they are doing it. And the reason they're doing it is that they don't like the things that the voters are passing. And rather than accepting that, hey, maybe we should follow the voters' will, and if the voters are disagreeing with their elected officials, maybe the elected officials should do things differently. Instead, they have said, we're going to make it impossible for the voters to express their will or do anything at all. The entire Amendment 4 saga is an example of the legislature just flat out refusing to follow the public will, refusing to do it for 20 years when people were asking them to. Then when the people finally got it together to pass it at the ballot box, doing exactly the opposite. And now, because the voters consistently have preferences, consistently have policies they want that the politicians don't, the politicians' answer has been, let's try and make it impossible for the voters to tell us what their opinions are. That's not the way democracy is supposed to work. We should be making it easier for people to put initiatives on the ballot, not just folks with very deep pockets and special interests that have a financial incentive to get it on. And at this point, under the rules that they are putting in place, that is more and more true. It is more expensive, harder, and that means that the folks who are most likely to get things placed on the ballot in the future are going to be special interests with direct financial incentives in spending that kind of money.
There's a question by a layman named Jeff. A little off subject. It appears the constitutional directive for congressional oversight no longer applies effectively. How are we not in a crisis? And I can answer, well, we are.
Yeah, I would agree. We are in a crisis, and we have, we have a public health crisis now. We have a constitutional crisis now, but we have had a crisis of values since the day that Donald Trump took office in this country. For the last 4 years, 3.5 years, we have had a crisis of values where he is pursuing policies that are just antithetical to what the majority of Americans want and what our principles say we are about. Every day just brings a new attack on civil liberties, on civil rights, and transparency, and accountability, and the Constitution, and real live people in real communities. Sometimes people want to pretend like all of these things he's doing are just like paperwork, just process stuff, blah, 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 who cares? And that couldn't be further from the truth. Every single action that he is taking and has taken has had very real consequences for real people in real communities all over this country, and in very damaging ways. So yes, we are in a crisis, and it is up to us to pull ourselves out of that crisis, because the Supreme Court isn't going to do it for us. If you think John Roberts is going to save you, good luck, have fun. Supreme Court's not going to save us. None of the courts are going to save us, right? They may be able to stop some of the worst abuses. They may control things. They may put limits on some things, as with this Amendment 4 litigation that we're talking about, right? We're happy that the courts are intervening in that way. But ultimately, the only way that we're going to stop these sorts of attacks over the long term is not to put faith in the courts, but rather to put faith in ourselves, to step up, to take action, and to do what we have to do to make sure that elected officials hear our voices, and that those who don't support the policies that we want and need get new jobs.
Yeah.
No one else is saying anything. Even Michael's quiet. He's not even muted. I don't want to put you on the spot, but because I was just trying to make a sense of what exactly is going on. Flynn, do you have any insight? What is going on with him with Barr trying to? I mean, I know what he's trying to do, but I don't understand the mechanism of what actually is going on there, and the judge he appointed, and
so. The whole thing is very bizarre, right? I mean, the whole thing is a rejected plot from a primetime soap opera that would be rejected for being implausible, right? Michael Flynn, has already confessed to the crime, right? He's already said, it is a crime, and I did it, and said that a long time ago. And the Justice Department agrees that he said that it's a crime and that he did it, but is now saying that he shouldn't have been prosecuted in the first place because the only reason he was interviewed was to try and entrap him, essentially, right? That's their argument. Now, mind you, there has been reporting that folks who are in the FBI have said that is not true, that was not the reason for the interview, that they were not surprised that happened, given other things they were pursuing in the interview. They weren't surprised that he lied to them about it, but entrapping him in that lie was not the fundamental purpose or the sole purpose of the interview. So, it would be one thing. It's much easier. I mean, the prosecutors can do what they want, right? But it's a lot easier to withdraw charges before someone has pled to it, right? Normally, if you're going to withdraw the charges, you do it before there has been a pleading or a finding of guilt or innocence. Normally, the withdrawal of charges comes not during the sentencing phase, which is what we're in now, right? But in the finding of fact and the finding of whether there was a violation of law. And that's what gives the judge who is still on the case some latitude, right? It gives him some ability. So there were a couple legal scholars who over the weekend wrote this op-ed that made the very true argument that because we're at the sentencing phase, the judge can actually continue the case, right? Can say, okay, if the prosecutor is no longer going to represent this interest, I'll just have someone else do it instead because of where we are in the case, because we're in the sentencing phase. And that is exactly what the judge has done. In fact, he named, he asked someone to give him a report essentially on what the options are, et cetera, but he named one of the people who wrote the op-ed as the person to do that. So I think we know what that finding is going to be. I think we know very well what's going to come back from it. And then when he does that, it's still entirely likely that the judge will sentence Michael Flynn to something. I will not consent to the withdrawal of the charges and the withdrawal of the thing, because he has to consent to it, right? And in a lot of cases, this would be perfunctory. The judge would simply say, okay, if the prosecutor no longer has an interest in pursuing this, it is not in the public interest to do so. But most cases aren't as high profile as this one is. Most cases, it is not clear that there is a pattern of political intimidation and corruption happening. And most cases, you wouldn't do this in the sentencing phase, you would do it in the earlier phase. So all of that gives the judge some latitude that he's clearly taking. And I'm very proud to say that the judge who is doing this is a Howard University alum, just like me. So go Bison.
Micah, could we return for a minute to the likely legal process once Judge Hinkle rules? Because I'm really concerned if the Supreme Court can get their hands on this. I see them staying it. I mean, if the timing works out, because I think that, anyone that's paying attention realizes that if everyone can vote or a large number are eligible to register, that they're more likely to register now because they're pissed. It's energized them. And they're likely to vote for Biden. And if that happens and Trump loses Florida, unless some spaceship lands or there's something none of us can imagine happening, it is almost impossible for Trump to win without Florida. And knowing all of that, and knowing what we know about the Republicans on the Supreme Court, they're going to do whatever they can to see that doesn't happen.
Yeah, so I think there are a couple things here. First, there is a process involved, right? So after the judge rules, the governor, the legislature will first have to appeal it to the circuit court in Atlanta.
Right.
And first, it goes to a panel of judges, right? So it goes to 3 judges. And it usually goes to the same panel that you had before earlier in the case, right? We know what they're going to do because that's what they did before, right? The likelihood that they've changed their minds in the intervening months is slim. Then it goes to the full panel, or he can request that it goes to an en banc hearing, right, where you get all of the judges. There, we have a couple things going for us, right? First, we have the fact that the last time they had an opportunity to do something about this, he couldn't get one single judge to side with him, right? Again, a very conservative circuit court. If you are in our shoes at the ACLU, right, you try and avoid the circuit court in Atlanta as much as possible. As much as possible, we try and file litigation that's not in this circuit because it is so hostile. So the fact that he couldn't get a single judge to side with him tells you something, right? It doesn't guarantee an outcome, right? But it shows you that even some conservatives have problems with what the legislature did. We have amicus briefs, so friend of the court briefs, folks who are not in the litigation, but who support the positions that we are articulating from some of the biggest right-wing think tanks, American Enterprise Institute, Heritage, folks like that have weighed in to say that they also agree that this is a bad thing, right? So I just don't, although I think it is very clear who has been the motivator behind this thing, I do think there are some conservatives enough to give cover to the court to not take a different position, right? And in fact, the 3 judges who were on our panel, right, the 3 judges who ruled in our favor from the beginning, actually normally rule with the conservative majority on the circuit court in Atlanta. Even though they were Democratic appointees, they are the most conservative Democratic appointees in almost the entire country. So 2 of them were from the Jimmy Carter administration, right, were appointed to the bench by Jimmy Carter. So the ideological breakdown here is not as clear-cut as the partisan breakdown in the state legislature was, which I think, again, gives us a little level of comfort. So you add up the timing of it, right? It takes a while. Like you get 30 days for each of the briefings, for each round of appeals, right? Like to some extent, you almost run out the clock just from the appeals process. To some extent, Judge Hinkle has an incentive to wait until like the beginning of June to issue his ruling, because then like August will have come and gone by the time the appeals could even really commence. And so then you get to the sort of appeals to the Supreme Court, where again, you know, the majority there is no friend of voting rights. But there is a procedural thing here where the chances that they would intervene in the injunction, I think are just really low. Not impossible, not, you know, I will not be completely knocked off my socks if it happens, but the likelihood that they intervene in an injunction, I think, are relatively low. Because I think what is most likely to happen is that the appeals court will say, we deny the stay of the injunction, but we'll take up the merits of the case at a later time. And that they would probably do that in, you know, several years from now. It would probably take them 2 years to do it. And then I could see this Supreme Court having a say, having something to say, taking up the question of the merits of the case. But we would have had, you know, months, years of implementation in the meantime, right? Which both make sure that people have the right to vote in the meantime, but also makes it a lot harder to undo later on, right? If people have been on the rolls for 2 years, it's a lot harder to kick them off at the end of it. And I feel this way in part because I came from Kansas, right? As you mentioned at the beginning, I was the executive director in Kansas, where we had Chris Kobach, who is still the reigning champ of vote suppressors, right? No one will ever begin to touch him, right? He is the greatest of all time, the GOAT, when it comes to vote suppression. And my entire 4-year tenure in Kansas was spent fighting Chris Kobach, and in particular fighting the voter registration law he had there that was the single most restrictive voter registration law in the entire country. We managed to get it struck down in court by a Republican appointee, a George W. Bush appointee to the bench, struck it down and sent him back to law school too, because she said he didn't know like the basics of procedure. And he appealed it to the circuit court, which there is also relatively conservative, not nearly as conservative as this one, but still not liberal pinko commie heaven, right? And he appealed it to the Supreme Court and didn't get anywhere, right? They all shut him down, even when he appealed to John Roberts, who, again, no friend of voting rights, refused to grant any relief. So, and keep in mind that that was important not just because of Kansas, but he had persuaded several other states, including some states that, like Georgia, that were perceived as very competitive, to do the same thing he had done in Kansas. And so if there was really a desire to manipulate the system for political partisan desires, they could have done so, right? But showed some level of restraint and didn't. And so I think the same thing is at least probable here, not guaranteed, but probable and certainly possible.
What if they skipped the en banc circuit and went directly from the panel? Would there be time for the Supreme Court to intervene in that instance? Because they don't have to. If they lose before the same three judges, which we expect is going to happen,
Yeah.
they could then say, we're going to skip the whole circuit. We'll go right to the Supreme Court. And if the Supreme Court wanted to be activists about it, would there be time for them to, put a stay on it while they consider the decision that they're going to issue next June?
I mean, I think the answer is yes, they could. I mean, I think it's.
If I were
if they were to do that, what would be most like? I mean, what would be most likely is that they put a stay on it, but remand it back. So send it back, and even if DeSantis tries to skip the en banc hearing, that the Supreme Court sends it back for an en banc hearing. The likelihood that the Supreme Court would take the case, especially one that would be as big as this one, without a full en banc hearing, is relatively low, right? I mean, again, with this crew, nothing is guaranteed. A lot of the procedural things that we took as sort of norms and that we took for granted have certainly deteriorated. So I wouldn't say that it's impossible, right? It's just more likely still that they would send it back for an en banc hearing. And again, that will take up some time. And the likelihood that the Supreme Court itself would rule on the merits without a full briefing, a full oral argument, I think is vanishingly low. And remember, the Supreme Court is going to adjourn in the next couple of weeks and then doesn't come back until the first Monday in October.
Right. Good. Okay. Well, I mean, that's very hopeful. I mean, because I think we know what the decision is going to, I mean, when I listened to Judge Hinkle, I mean, the one thing that was frightening to me was just how much he didn't like the defendants and the defendants' attorneys. They would object, and your attorneys didn't even have a chance to articulate why he should overrule it, and he would jump right in and say overruled. And everything you read in the newspaper about him just losing patience with the state.
They definitely tried his patience, and they definitely did things that were sort of guaranteed to tick him off, right? Like if you had a master class on how to tick off a federal judge, they would be the teachers of it right now.
Well, are they stupid, or is that their tactic to piss him off so he'd make a mistake? I mean, is that?
I think it's not. I think it's arrogance and hubris more than anything else, right?
Yeah.
I mean, I think they quickly caught, not quickly, but they gradually caught on to the fact that they were really irritating him. And so they modified their behavior, but by then they were a couple days into it and it was too late, right?
Right. So are there more questions?
Well, Arlene apparently missed a quick discussion of the assault weapons. What was the outcome of that? What did you, Michael, did you?
So I don't know where that ballot initiative currently stands, but I did note that the legislature is making it much, much harder for folks to pursue ballot initiatives at all. And I think that's consistent with them not wanting things like the assault weapons ballot initiative up for people to vote for at all.
No more questions? No more burning, burning desires? Okay. There was a good one on the Democrats, just, it's a little general, but since we have a moment, it appears that the Democratic politicians are useless in effectively protecting us and Constitution, there's not a whole lot they can do outside of raising their own army and attacking the White House. If the courts, you know, I always, growing up, I thought the courts arbitrated between the executive and the representative branch. If they're saying, well, we can't get involved because it's too, you know, it's the other two branches, then there's no one to put a check on the presidency. But I don't think it's necessarily Democratic politicians. Oh, there are certainly, you know, useless Democratic politicians, but Pelosi's not one of them.
No.
You know, I may not agree with everything Pelosi does, but that's one smart brain in that lady. So
The greatest speaker in the modern era, according to Paul Krugman, and look at what she's done in her 2 terms. She's the one person that Trump is nervous around. So, but it really is the courts just backing off. They could. I mean, I can't believe that they can even, that there can even be a question after Nixon and Clinton cases as to whether Trump has to turn over these documents. I mean, if they, but then you look at what John Roberts did in Shelby County, overturning 30 years of precedent. Citizens United, they don't really care. They're like Lily Tomlin's phone company. We're the phone company. We don't care. So there's some more questions came in, it looks like. I got 7 here.
No, I think we got them all. Oh, wait,
Oh, yeah.
You're right. One question above Arlene's. Well, Arlene's got answered, so it's no longer there. So, yeah, the Republicans prevented the House from getting the docs. Yeah, and the for getting the docs, literally the doctors.
Yeah. All right. Well, Micah, thank you so much.
Oh, no.
Take one more look at Arlene under the last question. She has another about the procedure, awaiting the judge's decision on its wording.
Oh, yeah.
What if the judge agrees with the wording?
So I believe the answer to this is that so long as it was collected and submitted, then it doesn't matter how long the judge takes, that the signatures are good, et cetera, et cetera. It is true that signatures have only a certain shelf life, and they made them shorter, right? Like the amount of time that you have to submit valid signatures was compressed, was condensed by the legislature. But then once you have signatures, once you have petitions, right, it goes to the Florida Supreme Court to say whether it can go on the ballot, whether it follows a single subject rule, et cetera, et cetera. But the presentation to the judge shouldn't be the problem unless, in this case, and I don't know the answer to this, sometimes people get approval or give it to the judge after they have already started collecting signatures. And so it may be that there are signatures that would have expired before they even got it to the judge in the first place, in which case those signatures would not be valid. The whole thing is very complicated and increasingly requires like very, very careful timing to make sure that you've got people collecting signatures and submitting the petition for approval review, all sort of on a hair's width timeline. So I'm afraid I don't know enough about that specific ballot initiative because it's not one that we work on, but it is it is true that signatures do have a shelf life and that there is a process for judicial approval to say that it conforms, but a lot of times those things don't exclude one another from proceeding.
Micah, one thing just occurred to me that we didn't talk about. Desmond Meade. I was really surprised that the defendants, they played a deposition of him, and he's, you know, I mean, he's the guy that started the whole thing, and he's saying there's some glitches with the legislation, but you know, we can live with it. I was really surprised by that, and I don't know if there's any backstory or there's something that they're not. It just seems bizarre.
I don't know that there's any backstory. I think it's just that, you know, I think they're committed to trying to work within the law as it exists. I think they have said that they wish that the law were different, but they're committed to trying to do what they can within the system, so long as it is the system, right? And, you know, I think different folks just sort of adopt different approaches to working with what we've got, and they're committed to trying to do everything they can to make sure that the folks who are still eligible can register, and we're committed to doing everything we can to increase the number of folks who can be registered, period. But I think if he had his druthers, and he said this publicly, if he had his druthers, Desmond wishes that they hadn't passed the bill either.
Right. Okay. So anyone else?
Thank you all.
Yeah.
Thank you all.
Thank.
Micah, have a safe trip home.
Yeah.
Well, thank you all very much for having me. I appreciate it. It's been a pleasure, and I look forward to a time where we might be able to get together in person again sometime in the future.
That would be great. Thanks again, Mike.
All right.
Okay.
Thanks. Good night, everyone.
Yeah. Thank you, David.
Thank you. Thank you, Lois. Okay.
I'm leaving.
Yeah, we'll say goodbye now. You can see for those people who are left, you can see my pinball machine in the corner there. See you next month, kids. Thanks everybody for hanging out.